Hello friends, today let us see something about intellectual property and intellectual property rights. Property may be of different types. It may be fixed, it may be floating, it may be fixed or current, it may be tangible, it may be intangible, it may be real, it may be fictitious. Property may be of different types. One such property is called as intellectual property. As the name indicates, it is a property which has a connection with the intellectual ability of a person. See, man is an intellectual animal. It is a special feature that he has got intellectual abilities. And man keeps on finding different things in the nature. Nature is full of different things. And we try to see, we try to find out, we try to experience many different things in the nature. There are so many things which we even do not know even today. So when we find something new in the nature which we were unaware of, that is called as discovery. So it was in existence but was not known to us. Now we know it, now we have experienced it, now we have seen it. Therefore it can be called as discovery. As against this, a man, by his intellectual capabilities, by his efforts, by his investment, by his time, finds out something new, creates something new. That is called as invention. Thus, there is a difference between discovery and invention. Discovery is knowing what is already in existence, which we were not knowing hence before. Just to give a simple example, the apple falling on the earth, well, was a very common thing that was taking place for a number of years, but some scientists could experience that, and he then knew, or he then called that particular phenomenon as gravitational force. So that was there in the nature. It is nothing new. What is new? For example, the steam has power. The steam has power. But experiencing that is a discovery. And using that steam for running railway engine is an invention. So invention is something new that is created by a man with his intellectual abilities, with his efforts, with his time, with his investment. That is invention. And this invention, well, everybody cannot do. Few people with extraordinary intellectual abilities can invent new things, and hence this becomes their property, their asset. It is called as intellectual property. A property, a thing, an invention which a man newly creates with his intellectual abilities. When you have this ability and invent something new, there is a need that the person inventing, the researcher, should get some right over that invention. And that legal right is technically called as intellectual property right. A right for his intellectual ability with which he has invented some new thing. So a law is made, a law is passed, and that law gives this right to the inventor. Now the question is, why this right is required to be given? The answer is very simple. The inventor applies his mind, applies his intellectual abilities, spends his money, spends his time, makes number of efforts, and then only he can invent. So to compensate all this, his time, his money, his efforts, well, there is a need to give some right to him. With this right, well, there can be some sort of reward to the inventor. If he gets the reward for his invention, he will continuously put his efforts and intellectual abilities for new and new inventions by which the society may be benefited. The new inventions make our life comfortable, more comfortable, and hence there is a need to give such legal rights to the inventor. This intellectual property right is of what type? What is the nature of it? This right gives exclusive right to the inventor whether to use that invention or not to use that invention. This choice is with him. Nobody else can make use of that invention without the permission of the inventor, without the permission of this intellectual property right holder. And this is the point where the inventor can earn. He can give the permission only when he gets some rewards, some returns, maybe in the form of royalty for giving the permit, for giving the license. Or he can sell out his invention, and for which he can get the price from the buyer. So he can sell the right, he can give it on royalty basis. This is the benefit of that right. So the right gives exclusive, the law gives the inventor the right, exclusive right of using, not using. Using it on his own or allowing somebody else to use it either on royalty basis or he can sell it. What are the types of intellectual property rights? The first type is patent, then is copyright, third one is trademark, fourth may be geographical indications, fifth may be industrial designs, then it could be trade secrets, and the seventh could be integrated circuits. All these are different types of intellectual property rights, and their names will tell what type of right is this. In different countries, laws are passed for protecting these rights, for granting these rights, and for cancelling also these rights. In 1994, WTO passed one agreement, and that agreement is TRIPS agreement, Trade Related Intellectual Property Rights Agreement. And with these TRIPS agreements, well, the intellectual property acts of different countries are synchronized. They are on the same path now, and they have given the intellectual property rights to different persons. I think this must have created some interest, particularly among the engineering field, the pharmacy field, and different other fields, to the students and the researchers. Because once they find out something new, it is in their interest, it is in the interest of the society at large that they apply for the intellectual property right under the respective acts, so that they can get the compensation as well as reward for their invention. And this is useful to the society, as I said, because these new inventions make our life easy. That's all today for intellectual property rights. Let us meet tomorrow. Let us meet next time with some different concept. Till then, goodbye.